Although Section 2 of the Lanham Act is titled Trademarks Registrable on the Principal Register, it lists what cannot receive a trademark registration. Let's explore some of these prohibitions. Immoral or scandalous matter. These prohibitions of the Lanham Act have been struck down by the United States Supreme Court in 2019 in Iancu v. Brunetti. That case was based on clothing with the letters FUCT, meaning friends you can trust. The USPTO had denied registration because it was scandalous. The Supreme Court said that the prohibition on immoral and scandalous marks violates the First Amendment. Deceptive marks. If your goods are tofu, you probably can't get a registration for ABC quality beef. Disparaging marks. We discussed previously a case called Mattel v. Tam, in which a band made up of people of Asian descent were denied a trademark registration for the name Slants because it was disparaging to people of Asian descent. The United States Supreme Court declared the portion of the Lanham Act that prohibited disparaging marks from being registered to violate the First Amendment. The name, signature, or portrait of a deceased president of the United States during the life of his widow, if any, except by the written consent of the widow. This section of the Lanham Act is currently being challenged and may be considered by the United States Supreme Court. The case involves an application for the mark Trump Too Small on shirts. The USPTO rejected the application. The Federal Circuit held that when applied to a mark that is critical of a public figure, the law violates the First Amendment under Tam and Brunetti. The USPTO asked the Supreme Court to review the decision. Until the Supreme Court decides whether it will take the case, the USPTO is suspending action on pending applications involving marks that are critical of government officials or public officials. Marks that falsely suggest a connection with persons living or dead, institutions, beliefs, or national symbols, or bring them into contempt or disrepute. I could not get a registration for the Elvis Law Firm if the estate of Elvis Presley does not actually have a connection to my law firm. Geographical identification used on or in connection with wines or spirits that identifies a place other than the origin of the goods. For example, I can't plant a vineyard in my backyard and expect to be able to call it Todd's Burgundy Wine Company. Flag or coat of arms or other insignia of the United States or of any state or municipality or of any foreign nation or any simulation thereof. Thus, if you want to start a fireworks stand with a logo that is mainly the United States flag, you may have some difficulty obtaining a registration. Consists of or comprises a name, portrait, or signature identifying a particular living individual except by his written consent. My favorite musician of all time, Jeremy Camp, is a registered trademark in classes 9, 25, and 41, and the consent of the living individual was part of the record. A mark that so resembles another mark registered with the USPTO likely to cause confusion, mistake, or to deceive. This is where the various likelihood of confusion tests come into play. A mark that is merely descriptive. I explained the trademark distinctiveness spectrum from fanciful to generic in a previous vlog. Click the I to learn more. Deceptively misdescriptive. For example, selling Lovey lamb covers that are not made of lambskin may be deceptively misdescriptive. Or, for another example, the oceanfront restaurant that is actually next to a trash dump is probably deceptively misdescriptive. Primarily geographically descriptive. For example, you may not be able to register Appalachian log homes or Smoky Mountain trails without secondary meaning. Primarily geographically misdescriptive. You could not register Cuban cigars for cigars that do not originate out of Cuba. In a somewhat related story, Toblerone is moving production of its chocolate to Slovakia, and as a result are removing the Matterhorn, a mountain in Switzerland, from its packaging. And it also says up here, Swiss milk chocolate with honey and almond nougat. Switzerland law may prohibit them from using Swiss. This may be more the result of strict Switzerland rules regarding the origin of chocolate, but it may also impact registrations with the USPTO. In a previous cheesy vlog, I also talked about locations related to cheese. Primarily merely a surname. Typically, you will not be able to register a last name as a trademark, even if your use of the name has nothing to do with it being a surname. You may be able to register it on the supplemental register, though. An example of a famous mark that is primarily merely a surname that was able to show secondary meaning and obtain a registration is McDonald's. Matter that is functional. If the mark itself is part of the invention, that is what patents are for. For example, the springs keeping a sign from blowing over are not a source identifier, but rather they are a functional part of the sign. Wow, that was a lot to take in. Be sure to talk to your trademark attorney if you have any questions. As always, trademarks are fun.